Okay.
Okay, good evening. And thank you so much to the Hillside Public Library for having me tonight. I'm Zahava Schechter. I'm an attorney for more than 34 years, primarily concentrating my practice in estate planning and administration and litigation and real estate. And tonight we're doing the second part of the program, which began last week on estate planning. Tonight we're doing estate administration and elder law. So hopefully everyone can see my screen. I will ask if you have questions, feel free to put them in the chat, and I'm happy to answer them at the end. Okay, and also if you have something more private and you want to contact me, that's fine. You can email me or you could call me. So I just told you a little bit about myself and the things I do, and I want to go straight into the program because there's so much to talk about. And the first subject we're going to talk about is elder law. And you see the definition there from Wikipedia. Basically, elder law deals with people who are getting older in age. It comprises many areas of the law, but the idea, the goal is financial freedom and autonomy through proper financial planning and long-term care planning. And I think that's a great definition. That's why I use that here, because we all, as we get older, we all want to stay well. We want to be autonomous. We want to be able to handle our own affairs. And the way to do that is through planning. So here are some of the issues we're going to talk about tonight. Estate planning we did last week. I will touch on it very briefly. If anyone has a question, you can always look at my YouTube channel or ask at the end. Tonight, we're going to talk about estate administration. So administration means someone has already died. And how do you pick up the pieces when someone dies? And we're certainly going to talk about tax questions. A lot of people don't like to talk about tax issues, but they're so important and you need to know what to do. We're talking about Medicaid. We're going to talk about disability and other long-term care issues, and we're going to talk about guardianship. I actually have two guardianship matters now. I generally don't do guardianship work. I do surrogates court work and estate planning administration, but I'm counsel to guardian, and guardianship is something that no one wants because you always want to be able to make your own decisions, but it's a very important part of the law. So we will talk about that. First thing I want to talk about is Medicare and Medicaid, how they're different. A lot of people think that they're the same, but they're really not. So Medicare benefits, as you see, are age-based, right? You have to be 65 and older. Doesn't matter if you're a billionaire. If you are 65 or older, you qualify for Medicare. Medicaid benefits are needs-based. You can be 1 day old and qualify for Medicaid. It has to do with how much money you have. And basically, we're talking about poor people. That's what we're talking about. Medicare does not pay for long-term care. A lot of people say, oh, well, if I need fill in the blank, Medicare will pay for it. No, Medicare does not. That's why long-term care insurance is so important. I've had long-term care insurance and I don't sell it, but I'm a big believer. I've had it since I was in my late 30s because I saw people around me, my clients, who were ill and no longer could qualify for long-term care insurance. So here's the kicker. If you need it and you don't have it in place, it's too late to qualify. So you need to apply when you're well. We're going to go talk a little bit about Medicaid. When I say a little bit, it's because really you could do a whole program on Medicaid. But there are three types of Medicaid. The first is institutional nursing home. We're not talking about assisted living here. We're talking about nursing home. The second is home and community-based service, which is either aides coming or people helping you at home or an assisted living facility, one or the other, but not a nursing home. And the third is what's called regular Medicaid. It's for those who are disabled. You don't have to be at that point 65, or those who are age 65 plus or blind. And we're going to go on to explain just a little bit in brevity, I'll try to be brief, who qualifies for Medicaid, because that's a really big issue. You have to have limited assets. Medicaid is for poor people. All of us who work and pay all kinds of taxes, we pay into the Medicaid and other buckets. So that's why there's a litmus test for the financial ability and resources and the needs of the person applying. There you see what the qualifications are. Income under $1,732 a month. Actually, that's much higher than it's been in the past. Assets under $30,182. And you have to, you're not tested, but they review, nurses review your file, and you have to need some form of higher care, greater care than you're receiving now. Does that mean if you have income greater than that amount, you will not qualify? No, that doesn't mean it. There are things called pooled, P-O-O-L-E-D, pooled trusts, and you can put money in there. There are problems with that as well, because if there's any money in the pooled trust when you die, and everybody does die, nobody can get that money out. But again, this isn't a comprehensive Medicaid discussion. We're just talking about different options. So there are things to do if you have greater income, but it makes it harder, and there are other issues. I want to go to this chart, which I hope is helpful. Find yourself here. If you're single, if you're married with both spouses applying, or if you're married with one spouse applying, what the income limits are, etc. What I just said to you was kind of a shortened version of this, but you see what the qualifications and the maximum allowed assets are. I'll wait one more second in case you're still finding where you belong. And hopefully you got that. If not, I can come back to that later. So I want to talk about what's countable versus not countable. If anyone is receiving Holocaust restitution payments, though, that is not counted as income. Also, if you have any in New York, if you have if you're a veteran and you have certain kinds of beyond the basic pension, that is not income. However, look at the first paragraph. Everything else is included as income when figuring out, do you qualify or not? Employment wages, alimony, pension, Social Security, disability, Social Security income. A lot of people think, oh, I get Social Security. That's counted as income too. Gifts, etc. And also IRA distributions. Your required minimum distribution. So let's talk about what planning is necessary if you're thinking of maybe down the road you might need Medicaid or not. The current look back period, I can't tell you what it will be forever, but it's been like this for a while. And the look back period is the period from which you transfer an asset or many assets, and then you apply down the road for Medicaid. So for example, currently for nursing home, it's 5 years. Today is February 29th, 2024. If on March 1st, if today I divested myself of all my assets, and that's what you have to do. You can't keep your house and keep all your bank accounts and everything, and then expect to go on Medicaid. It doesn't work that way. You have to lose control of your assets to make yourself poor. Excuse me, right? That's what you're doing. You're making yourself poor. So if today I divested myself of all my assets, on March 1st, 2029, if I apply for Medicaid, for nursing home Medicaid, the here in Nassau County Department of Social Services, which is in Uniondale, they can't say, well, Zahava, 5 years and 1 day ago, you had X dollars and you purposely made yourself poor. It doesn't matter. As long as 5 years have passed, they can't even look into it. For community Medicaid, assisted living, it's 30 months, and there will be more changes because New York, in New York, every county is responsible for its own Medicaid program. And as you probably know, New York currently has a deficit, and certainly in Nassau County, there are a lot of people applying for Medicaid. I do want to touch briefly, hopefully you were here last week, but if not, it is so important to do planning, not only Medicaid planning, if that's what you wish. Not everybody can or should do Medicaid planning, but basic planning, effective while you're alive, or the healthcare proxy, durable power of attorney, and then only effective after you are deceased, the will. I'm not going to talk more about that, but Everybody needs that. What happens with a trust after someone dies? I get this question all the time. And it matters if the trust, again, a trust, that we went into this more last week, but a trust is an entity. You can't touch it, you can't feel it, and you move assets into it. If the trust was revocable, meaning it's the Zahava Schechter revocable trust, I set it up during my lifetime, and then I die, my assets get a step up in basis. What does that mean? That means, and this is where if you have paper and pen, it's good. If I bought my house at $100,000 and I sell it during my lifetime for $800,000, I have a $700,000 appreciation, right? That's the profit I've made. Every owner is entitled to $250,000 of appreciation. So as a result, 100 plus 250 is 350. So 800 minus 350 is 450. That $450,000. That's the amount of appreciation in my example upon which I have to pay capital gains tax. That doesn't mean I'm paying tax of $450,000, but depending on what bracket I'm in, it might be 30%. 30% might be $130,000. I mean, it gets expensive, right? I'm paying a tax on the profit I've made above the exemption level. I hope I haven't lost everyone. But here's the point about a revocable trust. Zahava Schechter I transferred my house into the trust. When I die, it's a revocable trust. I control it, I can change it, I can do anything I want. When I die, the cost basis is no longer 100,000. It's now 800,000 or whatever it is at time of death. So hopefully my beneficiaries will have no capital gains tax. I've just saved my children or whomever, my husband, whomever, $100 and something thousand. Not bad, right? So that's why it's a good thing if you have a revocable trust, you get a step up in basis. Can you get a step up in basis in an irrevocable trust? So irrevocable, let's talk about this for a minute. Irrevocable means I cannot change it, right? Cannot be changed, cannot be amended. Zahava Schechter is transferring, and this is what people do who have a home and want to qualify for Medicaid. Zahava Schechter is transferring her house to the Zahava Schechter Irrevocable Trust. The trust gets the same cost basis of 100,000 that I had when I bought the house. So when I die, what is the cost basis? Still 100,000. There is no step up. So my trustees, whoever they are, of this irrevocable trust are going to be paying capital gains tax. Okay, hopefully I didn't lose anybody, but there are important differences. Testamentary trust, that's a different type of trust. That is dependent upon your will. So if you have a will, and in your will it says, I'm going to set up this testamentary trust. If there's a problem with your will, the testamentary trust cannot be created because it's solely dependent upon the will. So these are just some examples of what happens when someone dies with a trust. Okay, we're going to move on. We started to talk about this last week, but we're going to get a little deeper into it this week. Here are some good reasons during your lifetime to create the trust. This helps with administration afterwards. It's all about control. You can control from the grave. So even after you die, the trust document that you've already set up, right, it creates the circumstances and the conditions upon which distributions may be made. Beneficiaries who receive governmental assistance, what happens to their assistance? So if I die, I don't have a trust, I die, and Nyla is my child, and she receives governmental assistance, and I die. And she's going to all of a sudden get all this money. Right after I die, she's going to inherit from me. She's no longer going to receive governmental assistance until she gets poor again, which may happen whenever it happens. But the point is, that may not be a good thing for her. I have a matter now with someone who is receiving governmental assistance. and we're trying to prevent him from being thrown off the rolls because he's getting a certain amount of money. For him, you know, most people think, oh, I'm inheriting or I'm getting a gift. That's wonderful, right? Not for people who get governmental assistance. A lot of people who do either are mentally incapacitated, or maybe they have a certain kind of disease. Whatever the case is, without governmental assistance, it's very hard for them to subsist. It's not always a good thing. Medicaid planning. Is Medicaid reimbursed after your death? The answer is yes. That is the answer, yes. So I have a house, and even if I don't sell my house, but I qualify for Medicaid because I don't have other assets and I don't have a lot of income, and I'm receiving aids in my house. I hope everyone's following me. And then I die. And in the meanwhile, Medicaid has paid out for my aids and my medication and my hospital visits and doctor's visits and everything else, right? Medicaid has paid out $1 million. Doesn't matter the amount. I'm throwing out $1 million. My house, when I die, is worth $800,000. It's still on my name. The deed still has my name. Medicaid is going to come and put a lien on that house. So let's look at this. If I or my children or whomever had to pay, I don't have long-term, I do have long-term care insurance, but if I didn't, somebody has to pay. $1 million was spent. So if Medicaid gets my house worth $800,000, that's a pretty good deal, right? My family saved $200,000. People don't generally look at it that way. Here's another example. My house is worth $800,000 and Medicaid paid $200,000. So they put a lien on my house, and my children can sell my house for $800,000, pay off the lien for $200,000, and keep $600,000. There are different options here, but anyone who thinks, oh, Medicaid isn't going to come after my house or my bank accounts or anything, no, of course they are. Truthfully, years ago, they didn't. I mean, years, like 15 years. But now there's a deficit. They go after everybody. Spendthrift, protecting beneficiaries from themselves. So I have clients who tell me everything about their children and their spouses and their, their loved ones. People who inherit money, we're talking about after someone dies as well as during their lifetime, but people who inherit money, who are drug addicts or alcoholics or gamblers or fill in the blank, they're going to spend that money. So you want to set up the trust maybe, because that way, by the way, these are all good reasons, really good reasons to set up a trust during your lifetime. You want to protect them from blowing all the money right away. Maybe it can last a little longer. We just talked about addiction and ease of administration. Not everyone can handle properties and bank accounts and whatever. It's just easy when everything is in one entity. So the trust has everything. Very easy. You don't have to probate a will. You don't need to wait for any time period. It's much easier. Now, I want to talk about estate tax exemption amounts. A lot of discussion about estate tax. What does that mean? That means when Zahava Schechter dies, you take a picture, like a photograph, at the moment of her death, of everything she owns, everything. Let's start with New York State. If I die in 2024 and my estate, meaning everything I own, the word estate means I'm dead. Everything I own is valued at under $6.94 million. I have no estate tax. I don't have, you see the federal, right? I don't have New York State estate tax. I don't have federal estate tax. I may have other issues, but I don't have estate tax. If Zahava Schechter has $13.61 million or more, or you see here, the federal government provides what's called portability. I don't want to go in depth in this, but a married couple can get up to $27.22 million as an exemption. But let's say I'm not married, so it's $13.61 million. If I have more than that, then I have to pay both New York State and federal estate tax. And if I'm between the two numbers, 6.94 and 13.61, I certainly have to pay New York. I have a client now who is not married, a man, he's not married, no children, and he's going to fall between the two. He's going to be off the cliff, as we call it, like the cliff, like a mountain with a cliff. and he's going to have very high estate tax. And so we've talked about different things he can do to reduce his estate under that threshold. Very important if you're in that range to do some good estate planning. Otherwise, a lot of your hard-earned money is going to go to the government. I don't think most of us want that, so it's good to do some planning. Okay. Estate administration. That means someone has died and we're now going to pick up the pieces. So let's talk about some terms which are important. If someone dies testate, that means there was a will, and the proceeding is called probate. Probate is actually the offering of a will and acceptance by the court. You may think you have a will and it's good. That doesn't mean the court has to accept it. I don't know if anyone realizes that. Just because you have a will doesn't mean it was properly done or that the court will say, okay, we're going to accept it. It doesn't always happen that way. There are problems. Now, if someone dies intestate, that means there's no will. That's called an administration. And it's important because there are different forms and different everything. And is there a difference? Definitely. First of all, there's difference in time. Nassau County, if you have a will, used to be I could get things done within a week or two. I could get the letters for the client to get the client appointed. Now it's probably 2 to 4 months. But if you don't have a will, you're looking at 4 to 6 months. And during the big part of COVID, it was much longer than that. It was 8 months even. So there is a difference. It's more expensive when there's no will because more documents are needed and more lawyer time and more court time. And it definitely takes longer. What happens to the power of attorney and the healthcare proxy after death? No longer valid. The power of attorney and the healthcare proxy are valid and effective and wonderful while the principal, the person who makes them, is alive. But once that person dies, they're no longer valid. That's when the will comes into play. Just like the will is valid but not effective before you die. So it's the opposite for the power of attorney and healthcare proxy. Who has standing to file a petition? So we're going to talk about, this is SCAPA, Surrogates Court Procedure Act, Section 1001. First of all, I want to say the only court in New York State to have jurisdiction, meaning can hear cases about someone who is deceased, is the Surrogates Court, SURROGATE''S. The judge is called a surrogate. That's the judge, surrogate. And the court where you file the proceeding is the court where the deceased person resided. Not where that person had vacation homes or where that person died, but what's the address on the driver's license or on the tax return or on the passport, whatever you have. What is your official legal address? If that's New Hyde Park in Nassau County, then then when you die, the proceeding must be held. There is no option. You can't go to Suffolk or Queens or wherever. You must go to Nassau County Surrogates Court. And we're going to now talk about standing. So standing means who has the right to petition? Who is an interested person? We're going to get to that in a minute. We talked about where the petition is filed. Who needs to be notified? Anyone in the immediate family, you'll see very soon. In the immediate family begins with a spouse, children. You always go down before you go up to parents and then siblings. Who has the power to act? No one until the court appoints someone. So just because someone, if Zahava Schechter dies and Nyla is my daughter and she's going to petition to be appointed the administrator of my estate because I don't have a will, or even if I have a will and in my will I nominate her, I write, I want Nyla to be my executor, there's nothing she can do. Even if she filed the petition, nothing she can do until the court issues what's called letters, whether it's letters testamentary, if there is a will, or letters of administration, if there is not a will. So how long does that take? Well, I just told you, it's taking 2 to 4 months if you have a will, maybe longer. I don't know. It depends on the employees, etc. And up to 6 months or more if you don't have a will. And in the meanwhile, you have things to do. You have to pay bills. You need to I don't know, handle things. Yeah, you're probably advancing money on your own. So you have to wait until the court appoints you. Okay, I try to inject some levity into my presentations. So I take it this will is contested. What I tell potential clients, even current clients, is it doesn't make sense to pay a lawyer to fight a will, right? Why unless there's a real reason, like there was undue influence, there was pressure, the person had dementia. I mean, unless you have a really strong reason to fight a will, that's what contesting a will is. Why would you do it? It's nasty, it's expensive, it's time consuming. Now, if you think that the will was not proper or the person was unduly influenced, that's a different story. But those are very high bars. It's very hard to prove that. And frankly, the only one who wins in a contest are the lawyers. So now we're going to go to SCAPA, again, Surrogates Court Procedure Act, Section 1001. Who gets to become the administrator of an estate when there's no will? This is, we're talking about no will. Because if you have a will, by the way, I can name anyone as beneficiary. I can name anyone as long as the person's 18 or over. I can name anyone to be my fiduciary, my executor. But that's not the case where there's no will. So let's talk about this. Letters must be granted, to persons who are distributees. That another word for distributee is heir at law. This is the statute, by the way. This is New York law. Of an intestate, right? If you're an heir at law of somebody who died without a will, that's why I'm going through these terms with you, and who is eligible. Eligible means you're over the age of 18, you're not a criminal, right? If you've been convicted of a crime, you're not eligible to serve and qualify. And here's the order: surviving spouse, etc. So I have a case now with a surviving spouse. It's a third wife, and their children from different marriages, and nobody really gets along. That happens a lot, unfortunately. So if the surviving spouse wants to, I'm not saying a prior spouse, it's the spouse who is married to the deceased at the time of the deceased death. So if the surviving spouse wants to be fiduciary and is otherwise eligible, it doesn't matter what the children say or the grandchildren or the father. It doesn't matter. Surviving spouse is first on the list. If you don't want your surviving spouse to be the fiduciary of your estate, make a will. Even if you do, make a will. There's no contest then. It's not like your children are going to come and say, no, the surviving spouse is not qualified. So, but the reason I'm mentioning this is the list. So it goes through to brothers or sisters. Now, if you don't have brothers or sisters, the public administrator steps in. I'm in the middle of some of those cases. They're called first cousin cases. If you're not married and you don't have children and your parents are dead and your siblings are dead, and we're looking at first cousins, the public administrator is going of that county, in our case, Nassau County, is going to get involved. And there's going to be a kinship hearing, and it's very expensive. It's very time consuming. I'm doing it now. And you have to prove that you are, in fact, the closest class of relative. Without going too much into this, it's a good idea to have a will just so you don't have to deal with kinship hearings. So who inherits? I know I'm going quickly. I apologize. Who inherits from the decedent? Decedent is a deceased person. That's what we call the person, decedent, when there is no will. So here is the daughter who wants a $5 advance on her inheritance. And the father says, no, you can't have that. She's got to wait, I guess, until he dies. So let's look at who inherits. Who are the distributees, the heirs at law? So if we have a nuclear family, not everybody has this kind of family, of dad, mom, and 3 children. And if dad dies, I'm sorry, I don't mean to pick on men, but if dad dies first, the distributees are mom and the 3 children, right? If mom dies first, it's dad and the 3 children. If both mom and dad die, it's the 3 children. So depending on families, by the way, half siblings or adopted siblings are considered siblings. So for example, if child 1 is adopted, that child takes in full, just like child 2, who is biological. And if child 1 and child 2 are not from the same marriage, so they're half siblings, but they're both from dad and dad dies, half siblings take 2. Keep that in mind. So now let's talk about, first we talked about who could stand up to be the fiduciary, to do the hard work. Now we're going to talk about how much money they get when you don't have a will. Granted, if you have a will, you say how much people get or what they get, what items they get. This is, if you don't have a plan, New York State is happy to put its plan into place for you. Not everybody likes New York State's plan, but if you don't have a plan, this is the default. If a deceased person is survived by a spouse and issue or children, okay, so you have a spouse and children, the spouse gets $50,000 and 1/2 of the rest, and the children share by representation. So I'm going to go back to this picture for a minute. So if child 1 dies, let's say dad dies, right? Dad dies, there's no will. We have mom, and then there were 3 children, but child 1, I can't make a thing here, I'm sorry. Child 1 is dead, but child 1 left children, meaning dad's grandchildren. I hope you're following. Dad's grandchildren from child 1 take in place of the deceased child 1. That's what by representation means. Okay. If you have a spouse and no issue, no children, the spouse gets the whole thing. If you have only children, then the children get everything, again, by representation. If any of the children predeceased, their children take. And then we go on and on. And you may have heard this term, another term for by representation is per stirpes. It's a Latin term. We use that a lot. Okay. Special considerations where family members or beneficiaries receive government benefits. We already talked about this, but I'm going to review it again because it's worth reviewing. People who receive Medicaid, SSI, etc., lose their benefits usually when they receive gifts or inheritances greater than the allowable amount. Don't do that to people like that. Set up a trust so that it can pay for their additional needs as well as they can stay on a governmental assistance. Here's another thing I see people do. Not a good idea. Do not name people who receive benefits as joint owners or beneficiaries of assets, as that also disqualifies them. Okay. I want to talk about guardianship. An incapacitated person is someone over the age of 18, 18 being the age of majority. That's when you're an adult in New York State, who can't take care of himself or herself and needs someone to manage their care. Keep in mind, if you're adjudicated, if a judge finds you to be incapacitated, you're not making any more decisions. You've lost control of your ability to decide things about your own life, where you live, what you do, how you handle things. Most of these people can't do that for themselves. So someone else is needed, usually a family member. This kind of case is brought in Supreme Court. Supreme Court is not, it sounds like it's the highest court, right? But it's not. In New York State, that is the trial court. The highest court in New York State is called the Court of Appeals. That is, Supreme Court is the trial court. Guardianship, again, gives the right to make decisions for me to someone else. It's a problem. Not everybody, wants to lose control. Let's talk about a child. What if you have a child who is 17, not married, not in military service? Well, you are the guardian for that person. Whether where that person lives, meaning over the person where you live, where that 17-year-old goes to school, etc., or the property, money, especially if there's some kind of an award or an inheritance. What if someone is intellectually disabled? Is that enough? What if someone is developmentally disabled? There are all kinds of disabilities that the court reviews. So all of these things are things to think about if you have a family member who needs this kind of help. I want to talk about some miscellaneous matters. I talked about this briefly last week in terms of estate planning. Now I want to talk about them in terms of estate administration. Zahava Schechter is dead now, not alive, dead now. If I have a bank safe deposit box, even if I have it with a husband or with someone else, the bank seals the box when I die. So that is not a good thing to do. Please, I understand if you want to keep your jewels, you have jewels or you have money or whatever it is you want to put into your safe deposit box. Just know that in order for someone to get into it after Zahava Schechter dies, you're going to have to get a court order or someone will need to be appointed. You can't just go into the box and say, I'm a joint owner. It doesn't work that way. Chase, Bank of America, I've dealt with a lot of banks. They seal the box right away. Life insurance. Life insurance is a great form of estate planning. Let me tell you why. Because if Zahava Schechter has life insurance and I name Nyla as my beneficiary, when I die, Nyla presents my death certificate and her ID. She gets the money and she pays no tax. Insurance proceeds are not taxable. Isn't that great? So life insurance is a very good thing to do, especially if there are people who are dependent upon you and they need money, whether for college or living expenses, whatever it is, and they don't have to pay tax. Please check your beneficiary designations while you're alive. I have clients who have to come to me because Zahava Schechter left a bank account, did not name a beneficiary, and as a result, there's no one to get the money. So we have to go through the court system. But if Zahava Schechter had named Nyla as the beneficiary, we don't have to go through the court system. Nyla goes, she's named beneficiary on the account at Chase or TD Bank or wherever, and she brings in just like with the insurance, she brings in my death certificate and her ID, and she gets the money. The difference is this is taxable. Sorry, Nyla, but the life insurance is not, so something to think about. Pre or post-nuptial agreements for second marriages beyond. So I do these agreements, and one of the main things, yes, people are worried about what happens if you divorce, but one of the main things that people worry about is, I'm married, I have children, he has children, and we're married. I don't want his children to get my house. I don't want his children to get my money. So in the prenup or the post-nup, post is after you're married, prenup is easier for numerous reasons. But anyway, in that we say, my money when I die goes to my kids. If we want, we don't have to do it that way, but if that's what you want, which is what a lot of people want, and his money goes to his kids. I don't get it, and he doesn't get my money. So these are very important estate administration things. And are they effective? Absolutely. Okay, here's another cartoon. Upper class love. You see, he's proposing to her, but she's so wealthy. She's got to talk to her attorney about a prenup before they get married. Yep, that happens a lot. And we are just about near the end. So, as Benjamin Franklin said, in this world, nothing is certain except death and taxes. And by failing to prepare, you are preparing to fail. And if you have a question, I see there's some in the chat, I'm happy to answer, or you can call me afterwards or email me if you prefer. And I am going to pause. I'm going to stop my recording